I am here to tell you how an originalist would think about the question of Ted Cruz's eligibility, because believe it or not, I am an originalist. Now, I'm a living originalist, so that's a little odd, but nevertheless, I think I can make the argument for not just my version of originalism, but many other people's versions too. And in fact, the claim I'm going to make is it doesn't matter which version you are, whether you're my version, which is the right version, or whether you're a different kind of originalist. In fact, you'll probably come to pretty much the same place. Okay? That's basically what I'm going to do. Watch closely. My hands never leave my wrists. The idea is really simple. Most originalists, really since about the 80s or so, have been what we might call original public meaning originalists. That is, they argue that what is binding, see the real question is what's binding on you today? So they argue that what's binding on you today as law is the original public meaning of the constitutional text. Okay. So I'm that kind, and other originalists are that kind too. There are a small number who aren't original public meaning originalists, but most of them are. Now, the next thing you have to understand, and it's really, really important, it's like the most important thing in understanding how to think about originalism, is that the original public meaning of a text is not the same thing as how people expected that that text would be applied to some concrete controversy. That's really important. The original public meaning of the text is not the same thing as how people expected it would be applied. That's what we call original expected application. Now, my book makes a big deal about that distinction, but I just want to point out that after reading my book, most originalists now agree with me. So they also agree that the original meaning of the text is not the same thing as how people at the time expected it would be applied. The big difference between originalists is not that question. The big difference is how thick or how thin we cash out the idea of original public meaning. So I am, despite my girth, a thin original public meaning guy. Okay? And my good friends in the Federal Society and elsewhere who are originalists, some of them are a little thicker than I am. Can you believe that? And some of them are still thicker, and some of them are quite thick indeed. Right? So the distinction is between thin and thick. Now, my version is that the original public meaning is the original semantic meaning of the words in the text or phrases in the text. Any legal terms of art, which you can't tell from looking at the definitions of the words or phrases. So those would be like legal terms like bill of attainder, as Larry said. And then finally, any background context you need to understand what the sentences are saying. So for example, when it has numerals, those numerals are in base 10, right? Not base 12. That when it refers to the calendar, it's the Gregorian calendar, it's not the Jewish lunar calendar. So basically the idea is, it's very stripped down, it's very thin. What were the words mean at the time? What were the phrases mean? What do they mean in context? Are there any legal terms of art? And basically we go from there. Everything else that isn't solved by that has to be built out over time. It has to be constructed, okay? That's construction. Example, equal protection of the laws. Words equal protection of the laws in 1868 mean something. They mean the same thing today. The words haven't changed their meaning. But how we apply equal protection of the laws, for example, to women's equality is different. That is, the people who wrote the 14th Amendment did not expect that it would change the common law rules under which women lost all their rights when they got married. But that doesn't tell you what the original public meaning is. That's just how they expected it would be applied. Today we can say the original public meaning is equal protection of the laws. And they believe that there shouldn't be class legislation, there shouldn't be caste legislation. If we apply these principles today, sex equality for women, not a problem. Even though they would have disagreed. That's the distinction, okay? Freedom of speech. Doesn't matter what they thought freedom of speech meant in practice, how they thought it would be applied. What matters is the word freedom of speech means the same thing today as it did then. We have to figure out what it means today. So that's a thin version of original public meaning. Now, some of my friends, originalists, good originalists, disagree with me. They want a thicker conception of original public meaning. And what they mean by that is, they say, let's go back in history and look at the examples that were offered, and the principles that were offered, and the sort of policies that were at stake. And those are still binding on us They're baked into original public meaning. Now, the problem with thicker versions is the thicker you get, the more difficult it is to legitimate a modern state. You can't have a modern state, either at the state or federal level. You can't have a modern presidency. You can't have modern civil rights law. You can't have modern civil liberties law. Basically, the thicker you get, the more impossible this becomes. And this creates a serious problem of democratic legitimacy in the present. Remember, originalism is about legitimacy. It's about establishing legitimacy of law. So you have to not only maintain legitimacy at the moment that law is made, you have to maintain legitimacy over time. So the thicker you get, the more you have this problem. So that's why most originalists aren't totally thick, right? They have some version, they're somewhere between thin like me, and some are even thinner than me, but can you believe that? And some are thicker than me, but that's basically the idea. And we can talk about that more, but I just want you to give you the idea that that's what the debate over originalism is now. It's about thin or thick versions of originalism. I'll give you an example. So Justice Thomas, who is an originalist, original public meaning originalist, he is a much thicker originalist than I am. And he wrote an opinion involving violent video games, the Brown case. And in it, he said, look, I did some research. I figured out that at the time of the founding, children were not to speak, they were to listen. And no one could talk to your kid unless you gave permission. So from this, he concludes that at the time of the founding, freedom of speech did not apply to minors. They had no free speech rights, and nobody had a right to talk to them either, unless their parents gave permission. So his view is, who cares whether or not violent video games are speech, because kids have no free speech rights, and that includes people up to the age 18. No free speech rights at all. I think that's too thick. I think that's a confusion between the meaning of the word, freedom of speech, and the original expected application, how people expected it would be applied. That's too thick an account of original public meaning. And I don't want to get into whether who's right or who's wrong. It's just that I'm right and he's wrong. But I just want you to see how this works. Okay? And that's the big idea I want you to take away.